Imagine being a child who has been torn away from their security blanket, their parents, the ones who stopped the boogeyman from terrorizing the nights and curing their boo-boos when they scrape their knees. Now just imagine how they must feel when the CPS meant to protect them tears them away from their supposed abusers and places them with strangers who have zero comforting skills. They need to be calm. They are confused, lost, panicked, and needing their parents, but CPS took them away for the purpose of saving them. The kids don't even know why, and they are told that the parents they attach to no longer want them. What do you think that does? Do you think that this is how protecting children is supposed to look? Abolish CPS.
Psalm 127:3. Children are a heritage from the Lord, offspring a reward from Him. This suggests children are a precious gift from God to be valued and cared for.
In the United States, a child a minute is taken into DHS, CPS, and so on custody. The reality is their pics are already selected, you just don't know it. Being perfect no longer matters. It's what the adopting families are looking for.
Who is it stealing the children, you ask?
From caseworker to the White House, the buck stops at all levels, just not where it is supposed to be. The services your family needs, we the people have paid for to ensure your reunification. Title IV says, reunify at all costs. United, we stand means nothing to us when it comes to family values. Children are being ripped away from their families. Parents are reverting to addictive behaviors to cover the pain. The trauma caused by child removal is just being recognized, and the results are atrocious. Termination of parental rights is not healthy for anyone, just profitable for the people enforcing the line.
It's time Washington listens to the cries of our children, the wails of their mothers, and the rage growing in the fathers. These are our children. Keep your damn hands off them. We are coming to act on the behalf of the children God gave us to protect, and you kidnapped.
In the United States, CPS makes upwards of $3 billion per day on trafficking and selling our children. The corruption may start with the caseworker, but goes through the judicial system, passing the governor through the Senate and into the White House. The entire system has a hand in the business known as CPS.
Our children are stolen every minute of a 24-hour day. They are being robbed of their innocence, their trust, their happiness. As parents, we are isolated and betrayed by a government we trust. States are balancing budgets on kids' lives. Only 12% of the kids taken will be reunified. Title IV funding is being riveted with fraud.
right, good evening, everybody. This is your host, CPS Punisher, welcoming you to another episode of CPS Victims Hunting Justice. What's up, everybody? What a week it's been. What a week it's going to be. There's all kinds of hubbub in the news this week about CPS, a bunch of different stuff. We've kind of gone away from what we had been talking about, and that's the politics of what's going on, because we do have the vote that's coming up, and that's very important that we all be involved in this year's political election, because we want our cause to be a point that's brought up on the election. So please send in at abolishcps.com, at gmail.com. Send a request for the letter so you can start requesting that letter that is asking for an investigation into CPS and the fraud that they have committed using Title IV funding. We have that for you. I'm also getting ready to promote the Welfare Reform Act of 2024. I'm going to bring that out so that we can discuss that at some point here in the next few days. That I have written. It's a bill that I want to try all of us to get submitted to our local legislators to try to actually abolish CPS. And we'll talk about that. And then also Melissa and I have an upcoming book that we've been working on that will be out very shortly too. So don't forget, guys, we got the chat. I've moved again, so I don't know if I'm going to be where the chat's supposed to be. Right there's the chat right there. Check it out. Go ahead and leave comments there, questions, anything you guys have. Tonight we're going to kind of just go at it with you guys take the role and leave us with your questions or comments or whatever you guys have discussions of. If you have questions in your case, please feel free to go ahead and ask them. But we're going to kind of give this night back to you guys. As far as the topics go, we're going to run over some current events, things of that. If you see this show, please like and share it with your neighbors, share it with your friends. And we have a couple other guests that may be popping by. But let's bring out Melissa, see what Melissa has to say. Melissa, how are you doing?
I'm good. How are you doing?
I'm all right, hanging in there. I know it's been a week and a half for you, meaning like not a week and a half, but you know what I'm saying, like a busy week for you in your court system. But your story seems to be getting better and better.
Well, I think they're just getting a little more scared and scared.
Well, whatever it is, it's working, right?
Maybe. I'm not going to say it's successful until I hear a judge saying, give those damn kids back.
Right.
I've definitely learned never get my hopes up, because the second you do, they get pounced on so quick it ain't funny.
Everything comes crashing down. What do you, looking back at your case, what's the number one thing that you think you foobarred on? What do you think your number one mistake was?
Honestly, not filing more bar complaints against my attorneys. It's like my first attorney, she was court appointed, and she was actually a very good litigator, but after she walked out of the courtroom, you just kind of went to the wayside, because, she's only getting $100 an hour for her functioning hour. And so I wasn't an expensive enough client for her.
Right.
And my case was very extensive. Well, when Annabella's shelter hearing happened, she was supposed to appeal it, because I read to you the order earlier, where they said, oh yeah, remand the kid, use the police force, take the kid, reasonable effort to keep the kid at home isn't required because exigent circumstances happen. So with that being said, they lied to the judge to piss this judge off ahead of time. I mean, by this point, he already hated me. And when we got in there, and I specifically remember each part of the testimony, when we got in there, the director literally said everyone was approved, there was nothing wrong, we completed our parenting class, we've never failed a drug test, the child was thriving and doing well, the house was clean, all things were there and provided for. I mean, like, it was, decent. And I thought for sure that my kids were coming home. And the judge even said, wait a minute, I'm not going to return just kid. He says, if it's good enough for one kid, I'm going to return them all. So, of course, at first I'm like, hell yeah, all the kids are coming home. Right. And then he made a ruling to give them all to the department. But, so I had 2 attorneys there representing me, 1 attorney there representing JR, the father. I had 3 attorneys there, and the only one to speak was the court-appointed attorney. And she litigated. I mean, they're approved, was approved. It was as far as outside the attorneys and she's Melissa. We won argument. Yeah. We did the consideration was obvious. And then she went on vacation. And she filed her. She just didn't. I mean,
no. It seems like that we get a lot of that. These court-appointed attorneys aren't here to help us. They really aren't. And you're absolutely right. When they come into the courtroom or they come into an argument, it seems like for a moment that they might be wanting to help you or they're there to benefit you. But then we fastly discover, as soon as we leave that courtroom with these court-appointed attorneys, we're put back on the bottom of the pile, and we'll see you guys again in another couple of weeks or months or years in some cases, right? So, I mean, that part really brings you down because, there's nothing worse than being separated from your kid, and you just want this thing to go and go and go and just get on with it and get your kids home. And, of course, that's the way your mind feels the entire time, is that you want your kid to come home, period, end of story. And there's no way that your kid can't come home. Like, there's just no freaking way that your kid's not coming home. But then they step in and they do all of these other stupid little peddly moves, and your court-appointed attorney doesn't either appeal something, they don't, say, Your Honor, I object. They don't do any of this stuff that you see in courtroom TV, first of all. None of that stuff is existent in the actual courtroom. Like when you're gun and, loaded stock for bear, you're ready for that, your attorney to just come out and just sick 'em, boy. And they don't do that. Like if these attorneys aren't going to sit there and do for you what they should be doing for you, and they're going to
what made it really bad is, she had 2 good secretaries. She had one that handled all the criminal work and she did all the paralegal type stuff, and then she had another one that did all the family stuff. Okay, and Brooke was the family one. Yeah. And Terry was the criminal one. Both of them told me, you need to file a judicial complaint. She's waived your right, and she's not even going to tell you. She's going on vacation.
Right.
So literally, she intentionally botched it. And then when she got back, she says, well, I just decided I don't think this is an appealable time in this hearing. So there is a really nice layout of how the procedures work and when you can appeal. Article with the Alabama Bar. And I've actually met with the attorney that wrote that article because I tried to hire him. Anyways, he says straightforward, always appeal. If your shelter order, if the allegations for shelter care is based on allegation, not on hard proven fact. He says always appeal because hearsay is not admissible in an appeal.
That's interesting. That's very interesting. Hearsay is not in for an appeal. Because what I do know is that these court-appointed attorneys don't try for the appeal. They don't give you any information that when you are going up against them in the courtrooms, they don't give any information, or they don't fight any fights, they don't bring up any arguments that you will be able to use in the appeal. I know that for a fact. Like, there's nothing, and I didn't realize this. Like, an appeal isn't a second shot at becoming.
It's just a matter of getting kind of like a final judgment on the record that you already have. It literally is a review of the record. Right. And if the record ain't reflecting well, you're screwed.
Right. And you can only argue what was argued at your trial. So if nothing was brought up pertaining to certain circumstances in your trial, then you can't use that. You can't use, everything goes out the window. The attorney lied, or the caseworker lied, and all of this, and this person did this, and the bogus paperwork, and all this stuff. If none of that was drawn up during your trial, it is no good. You can't bring it up in your appeal. Like, it's not, you know what I mean? So people don't understand that. People think that the appeal, you just get a second run at this, and that's not at all how this goes. It couldn't even be closer from false. You know, like, the appeal is your second chance at making sure that everything was lawful and tidy in that courtroom when you were at trial. That's it. That's all the appeal is good for. So if your lawyer doesn't bring up any sort of factual, contestable, any information like that, then you don't get the shot at it in the appeals room. It's like it never existed. So you move to that appeal, it just means that you've gone from a big trial to a little focus trial that they need to figure out if everything went okay during that little focus episode. So if you don't have it here, you're not bringing it to here. And that's the word that we need to get out to people and let them know that, look, this appeals, you need to pay attention to what your attorneys are doing when they're bringing you up for trial. You need to make sure that there's information in that trial that reaches the judge's ears, and that they know that you will be able to argue it down the line. Because if you don't have it, it's like use it or you lose it, I guess, kind of say. Now, there are people that will tell you that you can appeal this and do all kinds of things. But in fact, like, what you need to do is go by the rules that we were just saying to you, because that's not always the case. You're not always going to be able to appeal. You're not always going to be able to just walk in the courtroom and say what you want to say. And if you do those things, they'll do something called the frivolous lawsuit or a frivolous action. And they will actually stop you from ever being able to make a motion or make any sort of movement on your case. I mean, that's
right.
That's what happens there. So, I mean, all of these things, are just things that people need to pay attention to. They need to remember that this is what's going on. And, that's pretty much how that works in the appeals thing. It's just so important, and people need to take heed to that. Herbert, you here?
Yeah, Herbert's here.
What's happening, man?
Good. How you doing?
Good. How you doing tonight, buddy?
Pretty good. How are you, Melissa?
Oh, I'm good. How are you?
Okay. I got a mouthful from Candace. Oh my
Lord.
God. Oh boy. Oh boy.
Oh boy. Yeah. Well, we'll keep that one. That's a whole other show. But what does she have to say? Let's just hear what she had to say quick.
I'm sorry, say that again?
So just give a little quick taste of what you were chewed out
about. Quick taste. The little quick taste is that she thinks that every state is the same. Like she could carry her little 22 and go anywhere she wants. And I said to her, no. She ended up in New York State. Something happened. She had a 22 caliber. She thinks she could register it and all that. I said, New York State doesn't work that way. You got to have a license. You got a felon. You're a felon in New York State. I said, if you're a non-violent felon, which is something that Melissa taught me, in Michigan, for example, you can get a firearm if you're a non-violent felon. But if you're a non-violent felon in New York, you're not getting no firearm. Not going to happen.
Right. Yeah.
And arms about that, the Constitution, and the Constitution. Huh?
Yeah, you said up in arms.
Yeah, she's all up in arms about the Constitution, this, the Constitution, that. I said, let me tell you, I have a gun in New York State.
Right.
I said, you should have called me. I would have told you to sell the gun when you were in Mississippi or Alabama. Where she's from? Alabama, right?
Yeah, Alabama.
I said, I would told her sell the gun in Alabama and then go to your sister's house in New York State.
Yeah, that's crazy.
That's just that's just the skinny on it. There's more.
Yeah.
There's more to the story, but I just gave you a little taste.
Yeah. What else you got going on, Herbert? You got any more phone calls out there?
No more phone calls. And the ones that I did make, they're all the same. They're all similar. I haven't found any deviation of the norm in terms of what police do in terms of dealing with CPS. It all comes down to what I've always said. There's security guards to help out, CPS social workers and personnel when they go to parents' homes. For whether it's wellness.
Right, but what authority do the police have when they're in these situations?
When you say authority, the authority they have is to make sure when they go to the house, there's no confrontation. If the parents start to fight or something like that with the with the CPS personnel, then the police officer will step in, and that's disorderly conduct.
Okay.
Hits the CPS personnel. Now we have an assault.
Right.
So all the police are doing is upholding the law when they go, but they're not concerned about necessarily what's going on with the child, unless in some states where the police are told to go there for a wellness check. That surprised me. So CPS doesn't show up, but the police shows up to do a wellness check on a child because somebody called.
Wow. Okay.
Yeah. Not a lot of states, but there's some states where CPS calls the police to do a wellness check. They don't do it.
Oh, wow. That's crazy. What happens
But I
when
haven't
people
found any.
go into the home? What
I haven't
happens
found
when they
any.
go into the home? So the police go into the home. Let's say someone has a pop pipe on their dresser, or they're right there in plain sight of the police. Are the police allowed to seize that and take that pipe and use that as evidence?
Yeah, if it's in plain view, yes. If it's in plain view, they can take it.
And as long, let's say Herbert comes to my house, right?
Yes.
So you show up on the scene, one second here. Let me look for what I was looking for here. So here comes Herbert. He shows up on the scene. He's coming in to say, hey, look, we got some problems. You come in, you knock on my door. I invite you in, right? So you come into my house, and now you see I have a pop pipe sitting on my dresser or something right there when you come in the house.
Yes.
Now, the only reason you're coming in is because I invited you, right? Like, that's it.
Yes.
Otherwise, you have a warrant, correct?
Yes.
All right. So you come in. I have a pop pipe sitting on my drawer right there. You now arrest me. So go ahead from there. What would happen?
Okay. Well, then I can, first of all, I can take you in. Really, if it's a pipe, that's kind of hard stretch because there has to be residue. I mean, anybody could go to the vanity store and buy a pipe.
I have a little tiny bag of weed sitting there on the counter.
Okay, good. So you got, no. Let's put it this way. You got what appears to be weed.
Okay, yeah.
You see, it could be a bag of oregano. Right. I don't know if it's weed or not, but let's say I walked in a house and I smell weed. Okay. So as a result of smelling weed, and then I see what appears to be weed, I can confiscate that.
Okay.
Okay. And at that point, it all depends on how it rolls down. It's going to be depend on your attitude towards the police and back and forth. The police could take you in. If you're in a state, for example, if you have weed at your house and you're in Arizona, nobody cares because you're allowed to smoke weed in Arizona.
Right.
You're allowed to be, huh?
I said the same thing in Maine. You can have weed all over the place.
So if you're in Maine, it's in your house. I don't see how the Maine police could bother you.
So maybe here's a question further down this, and to clarify, so we can clarify. Here's Herbert's homework. Herbert, what role does marijuana in a house play for CPS when it's legal in that state?
That's a good question. Okay, let's put it this way. Let's say there's children in the house,
Yep.
and there's marijuana present in the house. How is that handled? My answer,
Right.
I don't know, but I'll research and find out.
Because that would be an interesting one, because we have a lot of parents that are out there that have lost their kids because of weed.
Yeah, so that's a good question, especially in a state like Maine and Arizona, where you are allowed to go to the dispensary.
Right.
That's a very good point.
And that's not right, and that's not even going to the dispensary from the medical dispensary. Here, as long as you're 18 plus, you can go to the weed store, go in there, get some joints, get whatever you want, some candies, and off you go. So that's
Well,
no
that's the same
different.
thing. No, I think maybe we're talking the same thing. The weeds. Let's call it the weed store.
Yeah, but I'm
Yeah.
saying it's not even medical here. Here it's recreational, so you don't even need
No,
a card.
no. Arizona's recreational also.
Right. So that's what I'm saying. My point is that you can do it. Anybody can just go do it. So what now is the ramifications for a family that has weed in their house and the kids are in it?
That's a good question. I gotta look into that one for you.
So I can tell you from a Michigan standpoint, in the state of Michigan, because they're a recreational state, if there's weed in the house, it must be kept in a locked box, just like a prescription or a handgun, out of reach. And if it's caught to be anywhere where they can access it, it is grounds to be considered like a failure to protect.
Okay, I will ride with Melissa on that. That makes a lot of sense. It's just like you have the right to carry a firearm, but you can't just leave your firearm on the table while you have children around. I compare the weed to a firearm.
Okay.
So, I
Melissa's
dropped off
explanation
the
is a good
screen for a minute because Kim had called me. Me and her were talking about that retroactive recusal that Charles drafted up. We were discussing that, and she says so because, in Kim's case, she had 13 judges recused from her case. The very first judge cited a case law. And me and her were discussing it. The case law actually says that every order issued is de novo and void, and that the case must start all over from the beginning. And no judge paid attention to it. They all just took turns recusing.
So she, in fact, has a free and clear slate.
Well, they still sold her kids, so it ain't that free and clear.
But she should, in essence, then be able to just go storm in and take those kids back. Where's Kim? Let's get her on here.
She's starting up her computer. She says she'll be in a moment.
Oh, okay.
Who are you bringing on, Candace?
No, Kim.
No. Kim.
Oh, Kim. Okay.
Yeah, she's got those. Hey, I'm gonna play a quick thing that I found today about with Nancy Schaefer here. I'm gonna play this for us real quick while we're waiting for Kim.
Okay.
This is pretty cool. Check this out. Share.
But your explanation, what you said before, Melissa, definitely sounds right.
Now, Alabama's a very weird state about medical marijuana and stuff, because here it's still medical. Well, you can't get weed. You can get edibles. You can get candies. You can get dabs. You can get vapes. But you cannot get actual bud.
So you're not allowed to have recreational smoking marijuana.
Well, no, it's medical, but you cannot have physical marijuana. I thought it was kind of crazy. Kind of ass backwards, actually.
No. What I'm saying, if you want to buy medical marijuana and make a blunt or whatever, you can't do that in Alabama.
No, there is no physical plant weed in the state. Everything is based off synthetic THC, from companies. They don't want people growing it.
Okay.
They don't want it farmed in the state.
Yeah, see, in Maine, you can have a certain amount of plants in each form. Each from seedling to flowering to budding. You're allowed to have.
Yeah, but anything over 99 plants is still federal. Even in the states that are, yours is recreational, right? It's still federal if you have more than 99 plants, juvenile or above.
Right. There's a lot of rules that federal government will still. I mean, it's still illegal to the federal government.
Right.
So that's the whole thing there. You know what I mean? So that just there's obviously a lot of things, but I was just really curious about like how does this work for CPS now? How does this work in the sense of them? But here I'm gonna play this here real quick.
I think Melissa hit it right on the head.
Well, my name is Nancy Schaefer, and I'm from the state of Georgia in the United States. And thank you for your gracious invitation.
Hey,
to
Darren.
join you tonight. And thanks
your
to
internet
all of you
sucks.
who have made
Not me.
this
That's not me.
incredible World Congress of Families number 5 in Amsterdam. It's a privilege for me to join you tonight and to be with you in some pro-family policy here. I will share with you on the unlimited power of Child Protective Services. I served in the Georgia State Senate, and after 4 years of viewing the ruthless and unsparing actions of Child Protective Services, also called CPS, which I will use tonight, I wrote a scathing report entitled "The Corrupt Business of Child Protective Services." Thank you. The report cost me my Senate seat. Here's some copies of the report, if you'd like to get one. However, there are causes worth losing over, and this is one. I'm going to talk some of the problems and then some realistic, maybe, solutions for families and children, and maybe look to some steps that we can take. This is not to say that there are not those children in wretched situations who need to be removed. There are, and we all agree. But tonight, I'm talking about those children removed from their homes intentionally for profit. Children are seized unnecessarily from their families due to the federal aid created in 1974 entitled the Adoption and Safe Families Act.
Right.
It offers financial incentives to the states that increase adoption numbers. To receive the adoption incentives or bonuses, local CPS must have more children. They must have more merchandise to sell. Is available when a child is placed in a foster home with strangers or placed in a mental health facility and medicated, usually against the parents' wishes.
All right, let's pause this right here because we got Kim on board with us. All right, Kim, how we doing tonight?
Hey, good. How are you?
Doing all right. We're doing all right. We're having a discussion about recusing of judges, and it seems to be that you are the specialty person of recusing of judges. Why don't you go ahead and
no. She's the one that just
So,
got lucky to piss off one and have 12 others get scared.
right. So she's 13-0, right?
Well, yep. I had 12 total recuse or disqualify for my case. Yes.
Hey,
Wow.
Darren, the first one
Yes.
jumped off the bench and chased her down the hallway.
And he really
Yes,
did too,
that
didn't
was hilarious. He did. He did. He got
But at the moment,
he got
it
mad
wasn't.
because do what?
At that moment, it had to have not been. It must have been pretty scary. It must be funny after the fact, but
No.
in that moment when the judge
No,
really
it was
comes after you,
hilarious. Even in the moment.
was it really?
Even in the
Oh, wow.
moment, it was so funny. It was hilarious. So what had happened was the attorney that was representing CPS, I had found out that so when you have a license to practice law, you are either issued a license to practice in the private sector or in the public sector. If you practice in the public, that means that you can represent John Q. Public. If you practice in the private sector, that means that you can represent the government or a government agency. So, the attorney for CPS is in Alabama. They are assistant attorney general, and that means that the public.
Right.
You still there?
Yeah, we're here.
Okay. So, anyway, whenever you represent license to represent the public, that means, you know, John Q. Public, a government agency. As a assistant attorney general, is to the public, not to the government.
Right.
So CPS holds themselves out as a governmental agency, and we all know that. As a matter of fact, Alabama CPS recently screwed up that they are not a government agency, that they are a business which administers government policy. So anyway, I actually called this attorney out for not having represent CPS, and it pissed off this judge something awful. He jumped off the bench and chased me down the hallway. And I spent the night in jail. The next day I got my car. The sheriff's deputies are wide-eyed. I'm back on, and it was quite funny. It was quite fun, but I laughed the entire.
That's funny show.
That
judge literally chased you off the bench.
Chased me off. What? As you could chase somebody on crutches, I had broke my and I was on crutches. So, but yeah, he literally came off the bench and chased me down the hall. Yep. So it was actually just a couple of weeks after this incident that he ended up recusing. And now that I'm telling this story again and thinking about this, because this was a little while ago, it actually makes sense why he recused at this point, because that act actually showed bias. So he recused because he had just shown bias in my case. Yeah, it was funny. It was quite funny. And after that, I had multiple other judges recuse. They all get scared when you start showing them that you know they screwed up. you start pointing it out, you start making it obvious and putting it into writing, then they start going, oh boy, we're not doing this, bye. So, yeah.
Now, what do you think about what Melissa? Okay, so what do you think about talking about the recusal, but using it in the past tense? So, like being able to recuse a judge from previous rulings or situations.
Well, actually, Melissa and I have actually been talking about this because that particular judge that chased me off the bench actually, he did something quite unique in my case. And again, this isn't something that I really paid much attention to recently because this happened in 2020. So it wasn't something that I really saw any relevance with until just here recently. With my case, this judge specifically cited a case law, while none of the other judges cited a case as to their reason for recusing. And I've been actually looking into this case, and the case that he used, basically, this judge declared de novo on everything that he did on my case. And he basically was telling the next judge who got the case that the case had to be completely reheard. And nobody did it. Nobody attempted to even restart the case in any way. So, for those of you who don't know, de novo is Latin for do-over, basically. It means start anew. And what that means is for whatever's being declared a de novo, whether it is a specific hearing or it's the case in its entirety, it has to go back to the day before the de novo was declared. So let's say that you go to court today for a traffic ticket and you're found guilty of speeding. And then tomorrow the judge declares de novo. Well, that ticket, we have to go back to yesterday. We have to go back to...
Before we go further, though, what's de novo for everybody that's listening?
De novo basically means do anew.
Okay.
Do over.
Okay.
Now, see, in my case, I have a partial de novo. My de novo only covers one hearing. So essentially, it's a mistrial due to no record. Where a full de novo is a mistrial of the entire case.
Okay.
With a start fresh.
All right. Okay. I'm sorry.
So
go ahead.
It's almost like if the case is completely void, and we're pretending like we're at the very, very, very beginning. So. In the case that this judge that chased me off the bench that he cited, he cited this case, and I started doing some research on it the other day and came across some information that shows that what he did in citing this case was he told the next judge, this is a de novo. You have to redo everything from the very beginning, from the very first petition that CPS filed to take my children. You have to reevaluate that as if it was just filed. And nobody did that. So because that wasn't done, I have the ability to go in and potentially get the entire case thrown out and start over as if my children were just taken yesterday. It's gonna be a process. Likely, what I'm gonna have to do is, the judge who terminated my rights, I'm gonna have to file with them to have the case ruled as a de novo. I'm going to have to provide this judge's recusal with the citation, with the explanation, how this applies, how that case applies to my case. I'm going to have to show the law where the de novo is applicable. And I'm going to have to ask this judge to completely de novo what I'll do is not necessarily, I'm not going to ask for de novo for the entire hearing, or the entire case, but for the initial petition for removal. If the initial petition for removal is de novoed, anything that happened after that is void. And I'm gonna ask for it in that way because I'm going to ask for it in that way because if I ask for the initial petition for removal to be de novoed and it ends up being denied and I take it to the appeals court and it's still denied and I take it to the Supreme Court and then the U.S. Supreme Court and it's still denied, I still have several other hearings that I can petition to de novo them as well. So if I do it as just de novo the entire case, it's a one shot and done. If it's done, I'm over. It's over. There's more I can do, other than appeal it to the higher courts. But if I try to do it with each individual hearing or each individual ruling that the judge made, then it's a different situation. So I will be able to have multiple shots added on this.
That's awesome. Now, does de novo, when you're pulling this stuff up with the recusal stuff, does this give you an instance to get yourself back into the appeals court? You've already been denied appeals.
Actually, no. No. Actually, it puts.
Right, understood. But is this considered like a new argument? Would you be able to argue like a new argument, like a Rule 60 or something like that with this? Say, oh, my judge didn't do this, they didn't accuse, or... how do you get this into the court?
Well, I'm just the first thing I'm going to do.
Actually, I would kind of think that the arguments of the case law may have to be brought forth under a Rule 60 because it's new evidence not originally known.
Well, see, because it was originally known. It was originally known, but it was disregarded by the court. So the way I'll have to bring it in is
they just didn't bother to read their homework.
Right. So what I'm going to have to do is I'm going to have to bring it in as a void judgment due to due process violation.
Okay.
Because it's not that there wasn't, it's not that it was evidence that we didn't know at the time. It's that the judges did not do their homework. Like Melissa just said, they did not do their homework. And since the judges did not do what they were supposed to do, if a judge doesn't do their job, then they are violating your due process rights. So I'm going to have to bring it in as such a way that it is a void judgment based on violations of due process.
You might try it as a constitutional challenge at the circuit court of the district court's violations.
Yeah, that's a possibility. That's a possibility to do that. I think that maybe you challenge it as a void judgment first and then go in with the constitutional challenge, because the constitutional challenge, if the constitutional challenge is not down, then the void judgment is something that I don't have the opportunity to do again. But if I do the void judgment, I still have the opportunity to do the constitutional challenge. So kind of, take the baby step before I take the giant leap.
The leap of faith, right. Wow, that's crazy.
Yeah.
Have you seen any successes in running this type of a scenario? Are there any successes in here that we can refer to say, wow, this really does work in the child safety world? I mean, the child professionals?
I
mean, or
have
is this
not looked into that yet. I haven't looked into that part of it yet. This is actually something that I found out. I found this information like 2:00 in the morning, and then I had to get up and I had to go to work this morning, and I literally just walked back in the door a few minutes ago. So I haven't had a chance to do a whole lot of research to find out if there are other cases where this has been successful. As you and Melissa both know, I have a tremendous faith in the Lord. And I was told a long time ago by the Lord that my children will come home. It's going to take a lot longer for them to come home than I want. For that is because my case is supposed to set precedents. It's supposed to be a case that ends up, there's supposed to be something that happens in it that nobody else has ever done, nobody else has ever thought about, and it ends up setting a massive precedent. And I think that this is probably what it is.
Nice.
Well, honestly, Kim, my case and your case and Chris's case are so screwed up between the three of us. We should be able, the three cases, we should be able to take down most of Alabama DHR.
Yes, you are right. You absolutely. We should be able to take down Alabama DHR with what we have for just these three cases. I mean, we're talking what?
Hold on one second. To answer Carrie's question, yes, you can sue workers in the U.S. District Court under a 1983 action in their personal capacities. Suing a judge, well, you got a better chance of winning the lottery most times. Suing lawyers, as long as you're not arguing malpractice and you're actually going for conspiracy or violation of due process, those are pretty easily upheld. In my case, we just filed yesterday. We filed arguments under a 42 USC 1985, and we filed under a 1983. So we're going under conspiracy and due process violations. As you were saying, Kim, about our three cases.
Due process, just so we can make sure everybody understands that caseworkers don't violate due process. Attorneys don't violate due process. Judges violate due process. The reason that judges violate due process is because they are the ones that take an oath to uphold the Constitution. The caseworkers do not. The lawyers do not. Only judges take an oath to uphold the Constitution. Lawyers take an oath to act within the confines of the law in their representation of their clients. Caseworkers, honestly, they don't have any kind of legal oath at all. But because they are acting as an administrative agency for government policy, that's when you're able to use violations under color of law, which is a similar concept to due process violations, but also a completely different concept. So due process is only violated by the court system, the court clerk, the judge, the bailiffs. That's who can violate your due process rights.
Or, like in my case, I was digging through the records in my case earlier today, and I had found my proofs of service. On Annabella's case, I was served 7 days after the 72-hour hearing. On Sarah's case in March, I wasn't served till May. My child support case, I got served last week, and I'm supposed to appear in court on March 10th. Because I'll just break out the DeLorean and hurry up and get my ass back there.
Right.
I asked the attorney. I said, could I write that in my response, Your Honor? Sorry, my DeLorean is broke.
My flux capacitor ain't capacitating. No fluxing going on here.
But I mean, that is one of the biggest violations of due process you see is a failure to have proper service.
Right. And a process server, which I actually am a process server as well. A process server, if the process server is serving on behalf of the court, then they can violate your due process rights as well. If they're serving on behalf of another party, then they would not violate your due process rights, but they could violate under color of law. So in Melissa's case, she's being served by the court, not necessarily by CPS. So that's a violation of her rights in that capacity. Especially if they have had the sheriffs being the ones to actually perform the service. And whenever you have a situation where we'll talk about Melissa, them failing to serve her properly. With my TPR, it was actually scheduled to be heard in September of 2022. I discovered in August of 2022 that my ex-husband had not been served. CPS had made, according to their information, had made multiple attempts to serve him at an address which legal documents will show he was banned from ever living at again in 2016. CPS had his current address in their records. Through my discovery, I was able to actually come across this address, and I contacted a friend of mine. I've got a restraining order against my ex-husband, and I wasn't going to have him violated on this restraining order because I was trying to approach him. So I had contacted a friend of mine who's a private investigator, and I had him go out to my ex-husband's home, the address that CPS had in their records, and I had drafted a document for him and asked the friend to take it to my ex-husband and explain to my ex-husband that next week we have court to hear whether or not our rights to our children will be terminated. My ex-husband had no idea about any of this. He had not been served a single document for any court date at all beyond the court date where the judge jumped off the bench and chased me down the hallway. Because once that judge left the recused, it went to another county, then back to the first county, then back to the second county. Then it went bouncing all over the place. And my ex-husband never received another document from either CPS or the courts after that. So we have multiple hearings that my ex-husband was supposed to have been served for, but he was not. So since service was not perfected, and what that means, service being perfected, is that the court, the documents you're being served, they have to be given to you within a certain period of time before court is scheduled to be heard. That means the period of time varies by state, and it also varies by the type of hearing. You can't be served to court for a 72-hour hearing, but they have to serve you. It cannot be served to you the day after the hearing. If it is served to you the day after the hearing, a month after the hearing, 6 months after the hearing, you can actually have that hearing thrown out, the ruling of that hearing thrown out for improper service, because that is a violation of due process. That's one of the violations there are, is failure to perfect service. And what that means is that the court did not act in accordance with due process to notify you of a hearing, which could have major implications on your finances or your family.
Well, the hearing that I was served 2 months later, that was Sarah's dependency hearing, where they deemed her dependent in need of services. But the judge held that hearing off record, not recorded, refused to allow me to have an attorney, and would not respond when I said, I object, Your Honor, I have a right to speak. I was completely ignored, and he put out 3 orders from this off-record hearing. So the entire thing is a violation.
It is a violation. And so, Melissa, you said that the judge did not, there was no recording of this record, so of this hearing. So when you have a hearing occur, and this is why Melissa's got a de novo in one of her hearings, when you have a hearing occur, if you want to it, the way that a case is appealed is you file your appeal, you write what's called a brief, which is a specific type of motion that goes to the appeals court, and the appeals court has the lower court send up the record. When they send up the record, a transcript of the hearing is required to be part of the record. If there is no transcript, then they send it to a transcriptionist to be transcribed. If it cannot be transcribed, then that hearing is ruled as not having, never having happened. And it's then a de novo. But you have to request a de novo. It's not automatic. It's something that you have to file a de novo. So if you try to get the transcript from a hearing and they say that the
My
audio
judge
was
filed de
corrupted
novo on himself.
Now they will sometimes one will. It's rare. It's very rare. And in my case, the case that the judge used to recuse himself, after having looked it up, he basically did the same thing. He filed de novo on himself. Just nobody paid any attention to it. So basically, if you try to get a record and there is none, then you move for a de novo. You move for a do-over. In law, one of the most basic things that they teach law students is, if it's not in writing, it did not happen. And that's why one of the biggest things that I try to stress with parents when I'm helping them is to do a parental court report. Your attorney, often, almost every single attorney that I've ever seen, whether it's a hired attorney or a court-appointed attorney, they will not write anything. They will not file any actual paperwork in the court. They just want to show up and speak. And the problem with that is, if you don't put something in writing, you're never going to see it. The appeals court is never going to know that you had a valid argument against it. And if you don't put within a certain period of time, lose the legal ability to do anything about that. So let's say that you're accused of beating your child. CPS puts in their petition for removal that mom punched the kid in the face 12 times. And this never happened. You tell your attorney, that never happened. My kid doesn't have a black eye, bruised, bloody face. My child looks absolutely fine. If I punched my kid in the face 12 times, then wouldn't they look like hell? Well, the attorney should immediately say, okay, here is the paper that CPS filed. This is what they're accusing you of. I need you to write out your version of events on here. I need you to tell me what's true, what's not true. and they are supposed to write up what's called an answer, and it's supposed to be filed in the court. But they won't do this because it takes time away from their paying cases. So what I show parents how to do a lot of times is a parental court report. And what that is since most courts will not allow parents to file motions when they have an attorney of record, but courts will allow parents to file a court report. So the court report is their version of everything that has happened since the last hearing. So you can talk about the initial petition for removal says I did A, B, C, D, E, and F. And that's not true. And here's the proof. Here's the proof I didn't do this. Here's the proof I didn't do that. That way, your voice can be heard, because Brenda, you're right. They a lot of times do not let you object. Unless you understand procedure in a courtroom, the judge is not going to let you object. But if you get it in writing, you file it to the court record, it doesn't matter if they let you object, because it's on the record. And when you take it to the appeals court's going to see your arguments there.
Where do you file?
While you were made to shut up in court. Do what?
How do you file for the court report?
The parental court report, there's not a prefab document that the court has. The parental court report is actually one that a mentor of mine and I developed a couple of years back.
Okay.
And we will adapt it as needed per state and get it to the parents so that they can use it. What we have so far is we have one developed for North Carolina and Alabama and Tennessee. Those are the three main ones, because those are the three main states that she and I have worked in. So we will adapt it to reflect another state if another parent needs it from another state.
So what I'm saying is, so if you want to see this, how would you obtain a court report?
It's not something that you see, Darren. It's something that you fill out. It's like a clarification of the record.
So it's like your own little sheet of yada yada yada.
Yeah, it's your diary to the judge of facts.
Gotcha. All right.
Essentially, it's your version of events. I've heard other advocates that like to use sovereign law talk about doing a affidavit of facts.
Yeah.
And it can kind of work a little bit the same way as an affidavit of truth, excuse me. It can kind of mimic a little bit on the way that looks, and the way that they try to intend for that to be. But it's a bit different, because with the parental court report, you don't put any case law in there. You don't put any statutory law in there. It is literally on XYZ day this happened. On XYZ day that happened. CPS said I did XYZ. That's not what happened. This happened. But you're also able to attach copies of your evidence, so that when the judge won't allow you to admit it into evidence, it's attached via this court report. So when CPS, whenever you go to court, the CPS worker will do a CPS court report. And it is them getting their lies on the record. So you need to make sure that you get your stuff on the record, because if you don't get it on there, if you don't respond to the things that they're saying about you in these court documents, then you're stipulating to the facts. That means you're essentially saying, yep, everything that they're saying is true.
It's true. Yep.
It's basically, if you don't deny it, you're admitting it.
Correct. And you know what? There seems like there's a lot of this. We need to get you back here. I don't know what you're doing tomorrow night, if you're available, or if you want to come in next week. But it seems like we have totally a bunch more that we could discuss on this matter. But we are way over our time at this point. if you're cool with that, that would be cool. We'll talk
Yeah,
about
definitely.
it. All right. Hey, Melissa, last thoughts for tonight?
Don't ever quit fighting for your kids. You're supposed to be their hero. Who's going to protect them if you give up?
All right. Kim, your last words for tonight.
It's always darkest before the dawn. I know that sounds like a cliche,
I really
but
like
I've seen it so many times. Melissa's mentioned several times on the show. Chris, he's my friend that killed himself back in October because CPS killed his kids. Kidnapped his kids,
Right.
and that was a very, very dark chapter for me, and it was difficult. It was very difficult, but in healing from that darkness, I've seen that there's light. There's a lot of light at the end of the tunnel. Don't give up. Just take it minute by minute. Take it hour by hour. Don't give up. There is light at the end of the tunnel if you just continue to push forward.
Hey, at least I found a tunnel.
No,
That's good. That's great.
for me, you dug a tunnel.
Herbert, last words, buddy.
Yeah, just make sure that the tunnel that you see is not no train coming towards you.
That would be my luck, Herbert.
Yeah. So my last words is just don't let the police in unless they have a warrant.
That's right.
You know, because you open up yourself to a whole can of worms once they're in the house. Anything illegal in plain view, they can hold you to.
Yep. That's right. Keep
Just
it out of
because a
sight.
cop is knocking at your door does not mean you have to open it. Not unless they have a warrant.
Yes, correct. No, you
Make
can
them-
open your door. You can open your door, and they're gonna say, "Can we come in?" You say
I
no.
wouldn't know.
You say,
I wouldn't open it.
No, you don't have to open it.
I'm
You
saying
don't.
you don't
What I'm
have
saying-
to.
No, you don't have to open it. But I'm just saying, if you do open it, they have to invite them. So I said, "Can we come in?" You say no. That's it.
Yep.
You see, that's it. Because if they force themselves in, that's just like doing a traffic stop, and they say, "Can I search your car?" And you say, "No. What reasons you have to search my car?" And they say, "Well, just get out the car. We're going to search it anyway." That's illegal.
Yep.
Just like if the police come and they're looking for a refrigerator, what they doing in the top dresser drawer looking for a refrigerator? They have a warrant for a refrigerator. So why are they up in your bedroom looking in your top dresser drawer? They don't belong there because a refrigerator can't fit there.
Well, it might if it's one of those little dorm size ones.
Oh
That
no,
never-
you should see the new mini fridges. They will hold 6 cans of soda.
But can the six?
So
Oh, they
but
have-
can,
They have
but,
even
but cannot go in
smaller
a
ones.
drawer of a dresser. That's not going to go in your dresser drawer. So they
yeah,
don't belong
it
in your
will.
dresser drawer.
Yeah, no, it will. They're like
Yeah,
1
yeah.
foot by 6 inches. Yeah, they're tiny.
Warrant has to
There's
specify.
little ones that are
the-
makeup.
The
There's little
warrant
ones
has
that are
to
makeup
specify the
fridges.
size. The warrant has to specify what the refrigerator is, the name, model, brand, model, and all the information. So if they say it's one of those that holds a 6-pack, yeah,
I disagree with that because the judge ordered a search warrant on my property, and he said everything that I own or that is in my possession that could hold something the size of a 14-year-old kid. He didn't
Yes.
lay out addresses. He didn't lay out vehicles. Nothing. He said, "Help
Yes.
yourself. Any force necessary." And he
Yes.
did not give it a date of use either.
yeah, I get that, Melissa. I get you, but he's not going to be in your kitchen drawer where you got your silverware looking for a kid. He might be in a closet. He might be in different areas where a kid could fit under the sink. A kid could fit under the sink. He could look all up in there, but he's not going to open up your drawer where you keep your stash, where you keep
Are
your
you
silverware.
kidding? The cops came here and they said, "Hey, Melissa, is Tori here?" I said, "No." I said, "Do you want to come in and search?" They said, "No, we don't want to come in there." They ain't stupid. They know I'm not stupid.
Herbert is right. Herbert is absolutely right. I have an attorney that represented my friend Chris. With his situation, they actually criminally charged him with custodial interference. And I got a friend of mine and a criminal attorney in Birmingham to represent Chris. His name is Victor Rebel, at Rebel Law Firm out of Birmingham, Alabama. And I'm telling you, this man is absolutely fantastic. He literally went to jail for one of his clients because the local law enforcement agency was violating his rights. They were issued, a search warrant was issued for the client's person and his vehicle to specifically locate a cell phone. Before the search warrant was executed, the client and Victor and one of his associate attorneys were sitting in the courtroom with the client. The client handed the cell phone to Victor and said, there's information on here that you need for my case. This was a custody case, divorce case. It was a whole big old thing, husband versus wife situation. So what ended up happening was they leave the courthouse, and standing right outside the courthouse, and you can actually look this up, it's all over YouTube. They approached Mr. Rebel and his client and his associate attorney, and they handed Mr. Rebel the search warrant. Well, Mr. Rebel said, okay, well, you can search his person. I'm standing right here while you search his person, and I'm telling my client to hand you his keys so you can go to his car. This is the car out in the parking lot. And the sheriff's deputy said, well, no, we don't need to do that because we know where the phone is at. It's in your associate's briefcase. And Mr. Rebel said, okay, what's the point? And the sheriff's deputy said, that's what we're here for. Mr. Rebel said, no, you can't have that. Well, yes, we can, because that's what the court order says. No, that is not what the warrant says. The warrant says that you're allowed to search my client's physical being and his vehicle. It does not say that you're allowed to search my person or my associate's person. You're only allowed to search my client and his property. So the sheriff's deputy arrested Mr. Rebel and his associate for obstruction of justice because they refused to allow the sheriff's deputy to have the phone, because the phone was turned over to them and was not on their client's person. Mr. Rebel sued the state of Alabama. He sued the county that had issued the warrant and the sheriff's department that had executed the warrant. He won a massive settlement. Them because warrants the client's person and his vehicle only.
That's correct. That's 100% correct.
So that's why it's extremely important that if you have a cop show up at your house, you ask for a warrant and you read it. You don't let them just hold it up and say it's right here and you let them walk in. You need to read that, because I can hand you a book. I can hand you a piece of paper and say, this is a warrant. This isn't a warrant. This is chicken scratch, but you don't know it is because I haven't let you see it. So until you actually read the warrant, it's not executed. They have to allow you to read the warrant before they can actually execute it, so that you can know what they are legally allowed to go after. So as Brenda just said, they looked in her drawers for her daughter and I. If that court order, that warrant did not give them the ability to look in drawers for her daughter and her, then they violated the sheriff's department, the police department violated your rights under color of law.
Yeah, but if the girl can fit under the sink in the kitchen or in the bathroom sink, they can look in there.
Yep.
But the girl's not going to be hiding in the refrigerator.
That's a good spot.
Brenda, if they didn't have a warrant to come into your home and you did not say that they were allowed to come in your home, anything that they obtained from your home is fruit of the poisonous tree. They're not allowed to use anything. That you could have the gun that killed JFK sitting right there with fingerprints all over it, and they can't use that to prove that you're the one that killed JFK.
No, they can't use that against me.
Hey, Kim.
It's not submissible.
Hey, Kim.
Yes.
We'll have to revisit this next week because we're 20 minutes over.
Yeah.
Yep. Yeah. All right, guys. Till tomorrow. All right. Thank you guys much for tonight. That was good. All right, guys. Again, if you guys have any questions, comments, or anything like that, please direct them to abolishcps.com@gmail.com. Make sure you check out abolishcps.com. Also, when you go to the YouTube channel, there's also a community in there that you guys should check out where we put updates and things like that. I'm also working on a little hosting site for us. I got a lot of things that are up and coming, plus some new apparel that's being designed. We'll get that out there, maybe doing some contests and things like that to get you guys into some of our apparel. But those things are coming, so bear in there with us. Share this show with your friends. We appreciate every one of you that are watching us daily, helping us out with this. Just keep sharing, keep letting people know, keep everything going on. I'm the CPS Punisher, and I'm out.